You're making it one. It isn't what you think it is. It isn't your burden. So if it's going to be an evidentiary hearing, if we're going to have the hearing today, they're the ones who have to produce the evidence. So the fact that if it's going to be an evidentiary hearing, you don't have the responsibility, it will be them who has the responsibility. They will present the evidence in the evidentiary hearing. In other words, we can still have the evidentiary hearing today if they've got whatever witnesses necessary to prove whatever it is. How about this? I'm prepared to take the risk that the appellate courts will say I made a mistake to have this hearing today.
I understand, Your Honor. We have to provide you with the case law that I discussed.
How about you just tell me what the case specifically says, and tell me why I can't proceed based on that case. Cite the case. Tell me what the cite the case is.
Regarding the same day due process violation.
Please cite the case. When I say cite, give me a case.
Jeffrey A. Messi appellant versus Karen M. Naraka appellee.
Do me a favor. You said Shippering, is that correct?
No, Messi, M-E-S-S-I-N-G. Versus Naraka, N-I-E-R-A-K.
Thank you. Now, it also has a number at the top.
Yes, sir. 230-SO3E962. I have copies for you if you like.
I appreciate that.
Yes.
Please.
And I also have the evidentiary case, which is Corans versus Siam.
The Corans versus Siam case is located at. Is this
I'm sorry.
Corans is H-E-R-R-A-N-Z versus Siam, S-I-A-M, and this is located at 2 Southern 3rd, 1105. It is a 3rd DCA case. Now, what should I go to? Let me know when you're ready. What do you want me to see in these cases?
The first one, with regards to evidentiary. On page 3, I highlighted blindsiding the party on the day of the hearing, the court will entertain evidence that a hearing not noticed as evidentiary hearing is the epitome of process. That one, I'm sorry, that's it. And that's if you were to go ahead and
Here's what I think I need you to understand about that. It's not an issue if it's not being objected to. In other words, you can proceed on the case if both parties agree to proceed. It is making one party proceed when that party is going to suffer that makes it the epitome of a violation of due process.
Correct, sir. That's why I'm objecting to proceeding after this discovery. I mean, I feel that I may have been sandbagged on this thing because they've got a bunch of potential evidence in this that they would like to submit, but I don't believe any of that's in the record. I assume you've received this booklet of documents that they are entering.
I'm slightly confused, and here's why. It reads defendant's motion to dismiss your case, your motion. I'm not sure how they can sandbag you when you're the one who filed the motion for which we are here today.
In their response, they got a bunch of evidence that they would like to enter. I'm not prepared to answer to that for all witnesses that I may need to reply all.
Your Honor, if I may say the only evidence that we have to submit as to the motion to quash issue is the return service that was filed in the case file in this case on March 22nd, 2024, nearly 9 months ago, and 2 letters that were served by Mr. Kowalski to
My objection, Your Honor.
You don't need to interrupt him. I don't know. Please continue.
Our 2 letters that Mr. Kowalski sent to plaintiffs and my firm, if you're aware of those letters that he sent, and we also attached those to our response to this motion, which was filed in this case. I just wanted to make that clear.
I think what he's doing is trying to point out to me that there's nothing in any of this document that qualifies as sandbagging. Things that you would have produced, I think you should know about. Secondly, most of what I'm looking at is case law. From tab 1 all the way on is not evidence, but case law. And the rest of what I'm looking at, some of it could be evidence, but it looks like also mostly motion.
Well, there are a number of items in your agendas from the city, other exhibits, certain are evidence.
But sir, they don't need to introduce things unless they can do it through a particular person, unless there's a stipulation. Now, if you're talking about something that came from the city, they may not be entitled to introduce that because it might not be something they can authenticate, but I don't know if that's their intent or not at this moment. It is the objection that comes at the moment that it happens. In other words, I can't foretell what you're going to do any more than I can foretell what they're prepared to do today. You're not saying that.
Yes, I believe you're referring to the exhibits, the complaint, which included agendas from city meetings. We're here on a motion to dismiss, as the board is well aware, it has to go to the court. The complaint included exhibits, except all those facts is true. That's the only reason that those were included as part of it.
If you understand if you don't understand what you're saying, you obviously received the complaint. And I say that only because you filed a motion to dismiss. So you received a copy of the complaint, and the complaint itself should have contained exhibits, because that becomes a part of the complaint itself. And what counsel is telling me is the exhibits that are in this book are the exhibits that were attached to the complaint. In other words, there's nothing new. But let me give you an opportunity to say that these exhibits are not attached to the complaint.
A moment, please, Father.
Yes, sir.
At this point, if we want to proceed, I just reiterate that I believe that it's improper to hear this portion of this case at least, motion to quash, because in their own case law, it states several times that it has to be an evidentiary hearing to that type of case.
What do you anticipate an evidentiary hearing would be? What is it that you anticipate would happen?
That
At the evidentiary hearing.
there would be evidence gathered
Okay. Give me an example of the evidence you think that would be presented.
like they would bring the processor in to be examined, cross-examined. Did they bring the processor with them today?
That's a relevant question. And did you bring the processor?
We did not, Your Honor, I'll cite we have a file, I'll cite the books of two cases where the burden isn't in the correct on burden initially on plaintiff to prove valid service, but that burden is satisfied by presenting a valid affidavit of service that's filed before filing.
In civil court, more so than criminal, for criminals like this, there are statutory burdens that are not met by just presenting affidavits and documents. If they've got an affidavit of service, and unless you've got a case that says otherwise, there are circumstances in which it would not be sufficient. If it calls into question validity of the affidavit.
Yes, sir.
But if there is an affidavit of service, that usually carries the day.
Right, theirs is not an affidavit, sir.
Okay, well, do you have an affidavit of service?
Your Honor, it's attached to Exhibit A to our response. It's also filed in the court file on March 22nd, 2023.
You say exhibit A to the response, but it's not in this.
It is, I'm sorry, I believe the tab note that you got is not tab exhibits. I have those before you, Your Honor.
But it's exhibit A.
I do have those, Your Honor, for you.
You're right, I see exhibits. Exhibit A is a return of service. It is and there's a jurat. There is the last page of Don Phillips swears to the accuracy of the document.
Yes, and I can, if I may, paragraphs 1 through 5 of the motion address the insufficiency of the return of service. Specifically, the return does not meet the standard of being regular on its face because the jurat is qualified. They use wiggle words.
I'm sorry, no. It does not, I'm sorry, you said regular on its face?
Correct. It is not regular. The standard.
Just get it in the record for a moment. Is there a case that says what you're saying?
Yes, I have.
I'm gonna need one, just one.
Okay. Because if you don't mind, because the jurat is qualified, stating to the best of my knowledge and belief, such a jurat is not qualified as an affidavit under Florida law. That's Hahn versus Frederick. And may I vote?
Please. I'm looking at a 1953 case called, the Florida Supreme Court case called Hahn versus Frederick. It's located at 66 7th 2nd, 823.
And I have others.
Well, you got one, so let me look at this one. Where in this particular case will I find that, to the best of my knowledge and belief, is incorrect?
You're right.
Take your time. I don't want you to rush.
of the state.
Now, you're reading it, but you're not telling me where to find it.
Yes, on the front page in the head notes.
These head notes are numbered. Do you know which head note I should look at?
Number one,
Okay. He's got a Supreme Court opinion from 30 whenever, but there is at least a second DCA opinion from 2010 that seems to support his argument. This is Bollinger versus Bay Gulf Credit Union, and in that case, we acknowledge a verified complaint may serve the same purpose as an affidavit supported or opposing a motion for a summary judgment. However, in order to be so considered, the allegation of the verified complaint must meet the requirements of the rule governing and supporting opposing affidavits. Rule 1.510E in turn provides that affidavits must be based on personal knowledge and showing, quote, and shall, quote, show affirmatively that the applicant is competent to testify to matters stated therein, end of quote. The verification which is improperly based on information and belief is insufficient to entitle the verifying party to relief because the verification is qualified in nature. And that case cites other cases.
If I may,
You may.
first of all, the Congress Frederick, the case that Mr. Robson cited just prior, as well as that case decided in different context than an affidavit of service. One is the one you just cited, I believe, Your Honor, is the verified complaint coming from the party itself, or a verified affidavit supporting a motion for summary judgment.
Do you have a case that says that affidavits are different?
I'm sorry, Your Honor?
If you're saying it's in a different context, if it's based on an affidavit different than an affidavit of service, do you have a case that would say that an affidavit is different? You can have information and belief in an affidavit. Do you have that case?
No, what I would point out is that the jurat that we're talking about today doesn't say based on information or something from another source. It says common knowledge and belief. I believe that case you cited says that the jurat has to be supported by personal knowledge. That's specifically what this jurat said.
To the best of my knowledge and belief, and I need to put my knowledge and belief as opposed to information. I need a case. I mean, I hear
I have a case.
I'm not talking to you right now. I hear you, but I need the case that supports your argument, counsel. Do you have a case that specifically talks about my knowledge and belief?
Yeah, the trial court correctly held.
The answer is yes?
Yes.
Okay, what is it? Hold on. Listen to me.
Yes, sir.
What is the name of the case?
Paul William Scott appellant
And what?
versus
Go ahead.
State of Florida appellant.
Okay, and what is the site?
The trial court correctly held that Scott
I'm sorry, what's the case number?
464 SO 2D 1171 Supreme Court, Florida,
What year?
1985.
And what does it say?
The trial court correctly held that Scott's certification was not an oath because the qualifying language contained therein. If the allegation proved to be false, the defendant would be able to simply respond that his certification was a false allegation and admit to the best of his knowledge. And did not know the allegation was false.
I'm not sure that that case has anything to do with this case. That's really not the same.
It just says we require more than that. The defendant must be able to affirmatively say this allegation is true and correct. On that document, they did not say true and correct. They said, to the best of my knowledge and belief, it's wiggle words. And if you look at the bottom portion of that, that's why I would love to be able to question their processor. I don't have any doubt why they didn't bring them. Because the bottom portion of that document says "are served." How many people refer to themselves as "are served"? Everything else is in first person on this document. Somebody else drafted that language and description on the bottom of that document. Not to mention, I was driving my wife out of that night. They described my wife's car, which was in the parking lot. the driveway of my house.
You're not trying to tell us. Now you're testifying. We're talking the legal argument. So let's refine ourselves to the argument.
I also have another.
So, give me a chance to read.
Yes, sir.
Yeah, you're not going to be able to win, but counsel, I'll give you another chance. I'm looking for a 5th District Court of Appeals case here. It's Jackson v. State, and it's located at 881 Southern 7666. This is an affidavit violation of probation. Court Jackson appeals the order revoking the probation of the affidavit violation on me. It was based on defense. We agree that Jackson pleaded guilty to misdemeanor possession of cannabis and was given probation. He was later charged with multiple violations. The quote affidavit of violation was signed by his probation officer, set forth the facts constituting the violation, and then at the end contained the following statement: under penalty of perjury, I declare that I have read the foregoing facts, and that the facts stated in it are true to the best of my knowledge and belief. A position based on the affidavit. Jackson filed a motion to dismiss, arguing that the arrest was legal. It actually falls on a different thing. It says we recognize that the charging document is, quote, verified, end quote, pursuant to 92.525 for the statute. However, the charging document verified by the probation officer, quote, under penalty of perjury is not the affidavit required by 948-06-1 for the statutes. Both documents would support the prosecution for perjury, but the latter must be sworn before a person authorized to administer oath. So it really doesn't come down on that language. So it's not something that I thought it was.
Your Honor, if I may.
Not yet. All right, you may now.
Thank you, sir. This is Greenspire Global Inc. versus Sarasota Green Group LLC.
What's the site?
363 SO3D 1150 District Court of Appeals, Florida 2nd District.
SO3D 1150?
1150, yes, sir. May I direct you to the...
Is it Wilson or Pierce?
This is Greenspire versus Sarasota Green.
Give me the site again.
363 SO.3D
All right, go to
1150.
Okay, yeah, direct me to what you want me to do.
So on the second page, third paragraph down, the affidavit represented that Cassidy had read SPG's Second Amendment complaint, and that the statements made therein are correct to the best of my personal knowledge, information, and belief. A verification which is improperly based on information and belief is insufficient to entitle verifying parties relief if verification is qualified in nature. Again, qualified in nature. They put that at the end of his document of his return of service because it simply wasn't true.
Response. Your Honor, if I may, a few things. First of all, I want to put forward to the record none of these cases that are presented this morning were provided.
I have to believe that.
None of these cases were provided. All of that aside, I still yet to hear a single case in this context that states that an affidavit of service did not include that based on knowledge and belief the language. And the only cases that he had presented this morning are cases in which they are in opposition to a motion for summary judgment, or I believe with regard to a warrant for arrest. This is a return of service by a process server who has provided information, i.e. the address of the defendant, the business address of the defendant, to make service. You'll note, in the return of service, it states that the right above Mr. Phillips' signature, foregoing document is backstated and it was incorrect. I'll also point you to...
Yeah, but the truth correct, but then it goes on to the qualifying language. And there lies the problem. I mean, I really think it's either true and correct and full stop, or it's true and correct to the best of my knowledge and belief. You know, it's true and correct, or it's not true and correct. It isn't to the best of my knowledge and belief.
And Your Honor, Mr. Rossi, as I stated earlier, the Nova Stelzner case, the plaintiff had the burden of providing a valid proof of service. At that point, Mr. Rossi has the burden of proving that anything within that return of service is incorrect. He did not provide any evidence.
Well, I don't know if you got evidence, but you haven't met your burden yet. The point that he's making is that you haven't met your burden, and I think he's right. At this moment, I still don't know that this juror is correct.
And Your Honor, it's also stated...
You're winning. You should let it go. Should be.
Your Honor, I would ask that...
Counsel, anything else?
Yes, Your Honor, if I may. All of the the issue of the validity of the jurat side, if you look at Rule 1.070 subsection B, there's a sentence in there that we cite in our response to Mr. Rossman, and it's, even after talking about proof of service, it specifically states, failure to make proof of service will not affect the validity of service. And so when you put all of that aside, even I would disagree, but even if the jurat is found to be valid, the failure to make a valid proof of service is not, according to the rule, does not affect the validity of the service itself. The evidence that we have provided, and what we have argued in our response to the case law is very clear, that when there is an attempt to evade service, a quote-unquote invalid service in which the summons is not handed directly into the defendant's hand, is waived. And we have an Haney versus Owen court case, no relation, Your Honor.
I'm not sure I'm following you. Because it seems to me that that's the evidentiary hearing that he's talking about.
Yes.
The attempt to evade service is nothing that I can assume. And proper service is required. Now, he clearly is on notice that is a point of service because he's here, but he's also entitled to make sure that he is served properly.
Absolutely, Your Honor. And if I may, I can go into exactly why, as a matter of law, he was served properly under circumstances.
So what I think I hear you saying is, you're going to be traveling under a different theory, which is, even if the jurat is incorrect, he's nonetheless appropriately served.
Yes, I'll caveat that briefly, Your Honor, that even if the jurat is correct, we still have not seen a single case or rule that applies to a return or affidavit of service that says it's saving to the
I'm just not prepared to parse it that way. I'm not prepared to agree with you that where jurats are concerned, there's one jurat for this type of case, but one jurat for this type of case. I'm not familiar with that. If you've got a case that says,
I don't rule, Your Honor.
if you've got a rule that says that, I can follow up.
I will say that there is a rule specific to notary jurats, and that's rule, statute 38.10. I'm sorry, it's not 38.38. It is 117.
And that's the jurat related specifically to
Notary public, Your Honor. And that, it's under subsection 12B, it specifically states that the jurat is effective when it says, presented to me by the document custodian to the best of my knowledge and belief. The photocopy document is not a biological right. Or, I'm sorry, I believe to the best of my knowledge.
which section should I find it in?
Subsection 12B.
Be what?
117.05.
11705. Use of notary commissions, unlawful use, all of that. And you said 12B. So I'm all the way down to 12, and I'm looking at B.
Notary public certificates of
Slow down. I can listen as fast as you can speak. I can't type that.
Another public must use a certificate in substantially the following form, notarizing and attested copy. And then say for county up, it provides 2 lines, and then the best of my knowledge, that photocopy document I work on. My point being that jurats this would be contradictory of the case law that Mr. Krosky has provided. So it is on a situation by situation basis.
How many of you for, I still don't see the top. I think that's the main
In the section where it states what form that to be, well,
I think serving someone to the best of my knowledge is not enough.
well, that's like my point, Congress. This doesn't have to do with service, neither did any of the cases that Mr. Krosky cited, that any of process, it's a rule, 1107.
The only thing that cites to that language is amendments to the rule. Nothing else cites that language. No case.
Sorry, what language are?
Failure to make proof of service will not affect the validity of the service. I was hoping to find a case that specifically cited to that language and explained it. Okay. You're going to need to respond because that language matters. And it says, failure to make proof of service will not affect the validity of the service itself. Now, in order to interpret that, it seems to me that even without the jurat, if there's actually a service, it's a valid service. So the failure to make proof of service, the jurat, wouldn't mean that there wasn't service. He takes a witness, that witness takes the stand, that witness testifies that that witness did in fact serve you or your residents in accordance with the rule, you're going to lose. And that's all that's going to be required. That's going to be my ruling today. So, to the extent that you're talking about this evidentiary hearing, that's what would become evidentiary. Do you have that? I'm sorry. Okay, so failure to make proof of service will not affect the validity of the service in and of itself. So failure to make proof of service will, I'm going to have to establish that there was service in order to establish that it exists. The proof that we're talking about, what he's talking about, wouldn't, I don't think, be necessary if you have someone take a stand and testify, I served that resident.
What we've also provided you, even if the court's understanding that the jurat is not proper for proof of service, is a signed document under penalty of perjury submitted in the record of this case. And when you look at what is contained within that document, that would be out for example, summary judgment. When you put that in the record and you analyze that document, it goes through exactly what it says. That document in the case law establishes it as a matter of law.
You just should give me a case law. I did on case law. You got a case law. Go ahead.
So, the case of Amy versus Olencourt, 245, 7 2nd, 671.
You have a copy?
Yes, and we have to provide it on the house.
I'm sorry, is it provided as in here?
In your book, yes. It's under tab 15.
Okay.
And the Amy case is identical to
245, 7 2nd, 671. Go ahead.
And the Amy case is identical to the circumstances here in this case, as attested to in the return service, which is signed by the processor, in which it states that the processor approached the defendant's house to serve the defendant's house.
I always give people a little hand stuff, and they talk a lot faster when they're standing in front of me. But I'm sure she cannot type as fast as you speak.
I apologize.
Okay.
The basis of service in this case is that Mr. Rossi, for a period of 2 months, evaded service. On more than, on 7, there were 7 attempts to serve him at his house and at his place. And this is all stated in the return service that you saw in the process. During which, at that time, Mr. Service had 2 letters coming to his name by law, acknowledging that he was.
That's evidence. He's introducing evidence at this point.
Which was,
That's
attached to our response.
So that's evidence at this point. We're not happy. If we were going to do an evidentiary hearing, I'd be glad to get into all of this. This is what
It is evidence, but not being considered by me as evidence. He's just making his argument. Now, I still need to know how this case is filed. So that's what I ought to ask you about.
Okay, I was just providing background, Your Honor. What the Haney case is, in that case, the defendant, the process server approached the defendant's house. The defendant ran inside of the house upon seeing the process server and locked the door. The process server knocked on the door, nobody answered. The process server left the service on the doorstep. Mr. Crosby, according to his motion, is stating that by the act of leaving the process on his doorstep, he was not properly served. The Haney case is that.
Your Honor, that's a mischaracterization.
You know, the way it works is he gets to go, then you get to go, then he gets to go. You don't both get to go. I can't have 2 people at the same time. Go ahead.
The court, I have a quote from the Haney case right now, Your Honor. It says, quote, "We fail to see the significance of the leaving process in the physical hands of the defendant when the defendant was physically present, was reasonably advised of the officer's presence and purpose, and should have had the secretary directing his hand by the simple seizing and opening the door to respond to the process." That is also stated in the Weaver case.
Yeah, I agree. That's not. If that's what you had, because I told him, who's going to testify that he was there and would not accept service?
We have to sign off on that.
That's it. What does it say?
If I can read it verbatim, Your Honor? Sure. The case. Our server arrived at the Department of Insurance Commission meeting location. Our server arrived at the Department of Insurance Commission meeting location at 324 East Pine Street, Department of Insurance, Florida, at approximately 5:50 p.m. on February 28, 2024. Our server located the defendant's vehicle, a blue Nissan bearing Florida tag 870C in the parking lot, and remained in visual contact with the vehicle at the attempt serving the defendant as connected to the meeting. Server was again provided a photo of the defendant by the client, and was suggested to go inside the commission meeting and try to identify the defendant. Server located the defendant inside the meeting area, seated amid several other persons. No one was there. Server attempted to gain the defendant's attention. However, as the defendant ignored the server and at one point moved to an alternate location within the room further away from the server. When the meeting was adjourned, the rest of the individuals around the defendant exited through the main doors, while the defendant, quote, bolted through the rear exit of the commission room. Server exited the front and returned to the defendant's vehicle after the defendant entered the vehicle registered and parked in front of the server's vehicle. Server called to him and began to advise him of service when, at approximately 7:20 p.m., the defendant quickly started his vehicle and narrowly missing the server's vehicle, sped out of the parking lot at significant speed, causing the tires to spin and squeal as he left the area. As he was departing, the server managed to toss the documents onto the hood of the defendant's vehicle. However, the defendant refused to stop and retrieve them. The server gathered the documents and returned to the defendant's residence, where the vehicle had been observed previously. The vehicle was not in the driveway, and the way that the resident's vehicle was positioned, he would not have been able to enter the garage area of the residence. The server canvassed the area in search of the defendant with negative results. Server took a position.
I'm just about it. Because you're not going to be able to win. Here's why. He gets to say that that's not true. He can take the stand right now, swear to oath, and say it didn't happen that way. And you've got to have someone here who I can evaluate. In other words, you've got to have a witness. One that he's entitled to cross-examine. So if you want me to rely on this, and you want me to believe him and disbelieve him, and there's no chance for cross-examination, you got to have the witness.
You didn't call, you didn't subpoena the witness. We provided the return of service.
It is your verdict. You got to have a witness. When shall I say? That doesn't answer my question. I'm sorry. As soon as possible. PM on the 13th of January.
I don't have my calendar in front of me. Is it possible that we could have multiple times to choose from? Yeah, I can get back to you on that. to make certain that I can have.
Is there somewhere we can pick a day and time that we know for sure you'll be available?
What day of the week is that, sir?
That's a Monday. What days are better for you?
Tuesday, probably would be a good day.
Tuesday the 14th, maybe?
That's fine.
And how about the times? What are the good times?
Morning is good, sir.
Morning, okay, so better than the afternoons. Tuesday, on that day I can't give you one. Tuesday the 21st, let's see what we got. I can't guarantee that.
And Robert, I don't understand if that is a continuance of this hearing or this will be a new hearing that will have next year.
No, it's continuance of this hearing. I'm not going to be able to work with a Tuesday, not in January. Is there any other day in January that you might be available?
I don't know about. We have a new
But you know Tuesdays are good days for you?
Yes, sir.
Here's what I can do. It's an in-person hearing, you don't need to be here. 8:30 in the morning. It's Tuesday, 21st. January 21st? Yeah, January 21st. But half hour, that's all you got. I got something at 9. So I need a witness, all I need to do is take a stand, and he can recite what he just, effectively what you just told me, and then you'll get a chance to cross him. And then it's one of those who do I believe kind of situations. Now, if I believe him, you lose. If I don't believe him, you win. But you do recognize that even if you win, at some point you're going to serve, which means we'll be standing right here. So you can fight it, but it's one of those why.
I'm just trying to follow along. That's all. And that was my whole intent to go into city hall meetings was to get my city.
I don't think about that, and I don't need to know about that. Because this really ain't about, at least I don't know what this lawsuit is about at all. But what is it? It's about action. Oh, okay. Well, anyways, you're right in the sense that if you want to have it done right, you're entitled to that. But the point I'm attempting to make at this point is eventually there will be service. Because there's another way to do it. If you end up not being able to be served, there's such a thing as notice. They can serve you by mail. I mean, there are lots of ways to serve a person. And it isn't futile, but it is never going to stop a lawsuit that you are not served. I don't know what your intent is. I'm just trying to make sure you understand that it's...
I do understand, but I'm just saying that not only are they represented by legal counsel, they are legal counsel themselves and should be held to, if not a higher standard, at least the standard of law.
You know, every now and then, parties actually just agree to accept service. And the reason they do that is because they recognize that there's some things that are not worth the fight.
And why, Your Honor? For the record, we have asked them to accept service. They only counsel on that.
Thank you, but not really the point. The point I'm attempting to make for you at this moment is that they're eventually going to serve you. That's all I'm trying to make. Now, if you insist upon doing whatever particular way, you have that as a right, because you're a citizen and the law applies to you. It exists as a right. It doesn't mean it's something that ought to be done. It's just a right. Okay? Is there anything else we need to address?
Your Honor, is that continuation of this hearing? I also want to be at...
What day did I tell you?
Tuesday, January 21st, 8:30 a.m.
One.
Your Honor,
That's
if I may just improve for a second. There's also a motion to dismiss filed by the defendant as part of this hearing. It's in the same file.
What are you talking about? Am I out of time? Do I have anything to do? What's going on now? I mean, because if we have that motion, I can address that now. Don't be asking.
That's fine, that's all right. I guess I was also going to say that if you only heard minutes on the 21st, we don't still have that many.
Let me find out whether I can. Because for example, with this motion, you don't get to raise your hand.